Good afternoon, and thank you for joining today's webinar, which is our annual Public Procurement Law Update. My name is Chris Taton, and this is my colleague Emma Butcher. For those of you who don't know us, we are lawyers who specialise in public procurement law, and we advise public bodies and bidders on challenges to procurement decisions. As with our last three annual updates, Brexit continues to be the dominant subject in an area of law that is derived almost entirely from the EU. Negotiations for the new deal between the UK and the EU started this week, and we'll look in this webinar about what that might mean for the future of procurement in the UK. We start, however, by reminding ourselves what we mean by a regulated public tender.
So the key piece of legislation that we're going to be talking about today is the Public Contracts Regulations 2015. Most of the tenders that you participate in or run will be governed by those regulations, and they apply in England, Wales and Northern Ireland. Some of the tenders you might deal with will be governed by other associated pieces of legislation, which we've listed on the slides there. And although we'll be largely talking about the public contracts regulations in this webinar, many of the same principles apply to all of the other pieces of legislation as well. So the sorts of tenders that are covered by those regulations are those which are run by public bodies and are above the financial thresholds, which were updated from the 1st of January this year. And again, the figures are set out on the slides there. There are some exceptions. Some specific types of contracts are subject to the light touch regime, and some basic requirements also still apply to below threshold contracts, but not the full regime.
Remarkably, this is the fourth annual update where we started by considering how Brexit will impact on the future of public procurement in the UK. And I'm afraid to say that again, we still do not have a final answer for you. Politically, a great deal has happened since our last annual update. We now have a Conservative government with a strong majority, rather than a Conservative government relying on the DUP to stay in power. And we've now left the EU. Well, sort of. More accurately, Parliament has passed the European Union Withdrawal Agreement Act, giving its approval to the terms of the withdrawal agreement. This statute received royal assent on the 23rd of January 2020, and the EU and the UK signed the withdrawal agreement the following day. At 11 PM on the 31st of January 2020, the European Communities Act 1972 was repealed, and the UK formally left the EU. To say we have left the EU in any meaningful sense is an exaggeration. We are now in the 11-month transition period or implementation period, during which EU law will continue to apply in the UK, whilst the UK and the EU seek to negotiate an agreement on the future relationship. The political declaration describes the aims of that agreement as an ambitious, broad, deep and flexible partnership across trade and economic cooperation, with a comprehensive and balanced free trade agreement at its core, law enforcement and criminal justice, foreign policy, security and defence, and wider areas of cooperation. We'll find out more in the coming months whether this will be achieved. The negotiations formally started on Monday. The agreement needs to be completed by the 31st of December 2020, if there is to be one. Boris Johnson has said there will be no extension to the transition period. If that is true, then by the time of our next annual procurement update, we should know what is happening to public procurement in the UK. For now, we're going to start by looking at what is happening to public procurement during the transition period, including how this will, to an extent, spill over into future years. The withdrawal agreement, signed by the UK and the EU in January this year, provides the detail of exactly how EU law will continue to apply to public procurement in the UK until at least the 31st of December 2020. Section 76(1) states that the EU procurement rules should apply to procedures launched by contracting authorities or contracting entities from the Member States or the UK before the end of the transition period and not yet finalised on the last day of the transition period. In the UK, the EU procurement rules are already part of our domestic legislation, including the public contracts regulations, the utilities regulations, the concessions regulations. Under the withdrawal agreement, the government is not permitted to amend that legislation during the transition period in a manner which does not comply with the EU directive. That does not mean that the government cannot amend the procurement regulations at all. There is already scope for that to be done under the EU directive. However, given what else the government has to achieve during the transition period, it seems highly unlikely that any significant changes will be made in the short term. Section 76.3 clarifies that procurement procedures are deemed to have launched when a call for competition or any other invitation to submit applications has been made in accordance with the relevant rules. This means, for example, that a tender started pursuant to an OJ notice published during the transition period will continue to be covered by EU procurement rules post 31 December 2020. Section 76.4 explains that procedures will be deemed to have finished on the publication of a contract award, where this is required, or conclusion of the contract, or where the contracting authority announces that the contract will not be awarded. This again means that EU procurement rules will continue to apply post-exit day. Section 76.2 emphasises the application of the principle of non-discrimination. As was the case before 31 January 2020, UK contracting authorities are not entitled to favour bids from companies based in the UK over bids from companies based in member states of the EU. And finally, Section 76.1b deals with framework agreements, and that includes contracts awarded under framework agreements. For those, the EU procurement rules will continue to apply until the existing framework agreement or the contracts being tendered under that framework agreement have expired. Given the length of some framework agreements, that means that EU procurement rules may continue to apply to some agreements and procurement activities for many years to come. So in the short term, nothing at all is likely to change. The big question is what will happen after exit day on the 31st of December 2020. And ultimately, this will depend on the outcome of the negotiations which started this week. There is already a basic legal framework in place which tells us what currently will happen on exit day. Under the European Union Withdrawal Act 2018, a snapshot of EU law in force on the 31st of December 2020 will be imported into UK domestic law. For procurement, most EU legislation is already part of UK law under the various procurement regulations. In addition, the Act will import the case law of the European Court of Justice as it stands on exit day into domestic law. Under the Act, government ministers are also given the power to make further secondary legislation to amend the existing legislation to make it consistent with the UK's departure from the EU. And concern has already been expressed about the scope of the legal changes that ministers might seek to make, but that is the subject for a different webinar. We also have two procurement statutory instruments which explain the specific changes which we made to the three sets of procurement regulations listed on this slide. On a practical level, they introduced the UK's new e-notification service, which we called Find a Tender. This will replace OJ for future procurement in the UK. The statutory instrument also removes the right of businesses based in the remaining EU member states to bid for UK public contracts, save where this is covered by the World Trade Organisation's Government Procurement Agreement. This reflects the position that will face UK businesses, who in turn will be excluded from bidding for public contracts in EU member states. The final deal being negotiated by the UK and the EU will determine whether greater access is given to their respective procurement markets post 31 December 2020. There are two issues that need to be addressed. First, which parts of the EU and the UK's respective procurement markets they will open up to the other. And second, what changes the UK might make to the current procedures under the EU regime for procuring public contracts in the UK. As mentioned earlier, negotiation of the deal started on Monday, with David Frost, the UK's chief negotiator, attending with 100 advisors and civil servants, working across the 10 working groups listed on this slide. In fact, the negotiations have had to be moved to a conference centre in Brussels because the European Commission's headquarter was not large enough. There is no specific negotiation group dealing with procurement, but clearly a subset of a number of the groups listed on this slide, not least trade in goods and services, will need to cover this subject. The media reports about the current negotiations have typically focused on the politically sensitive areas: access to UK's fishing, levelling the playing field, and the EU's demand for the UK to maintain similar standards on environmental, employment and state aid regulation. Not much has been said about procurement this week. The first place to look at what they might discuss is the text of the political declaration. Paragraph 46 states, noting the United Kingdom's intention to accede to the WTO Government Procurement Agreement, the parties should provide mutual opportunities in the parties' respective public procurement markets beyond their commitments under the GPA in areas of mutual interest, without prejudice to their domestic rules to protect their essential security. And paragraph 47 states the parties should also commit to standards based on those of the GPA, ensuring transparency of market opportunities, public procurement rules and practices. Building on these standards, the parties should address the risk of arbitrary behaviour when awarding contracts and make available remedies and review procedures, including before judicial authorities. These are fairly high-level, aspirational, non-binding statements. But what do we know of the UK and the EU's objectives from the negotiations which are currently taking place? On the 25th of February this year, the European Council authorised the European Commission to undertake the negotiations with the UK on the future deal. The terms of the negotiating directive, which confer this authority, state, "We aim at securing procurement opportunities on top of those guaranteed by the UK's access to the WTO Government Procurement Agreement." Again, not a huge amount of detail, but the starting point is the Government Procurement Agreement. The UK is currently a party to the GPA through its previous membership of the EU, which has been extended by agreement of the 19 parties to the GPA until the end of the transition period, 31st of December 2020. The Department of International Trade has explained what happens at the end of the transition period. They expect the UK to join the GPA on substantially the same terms as the EU agreed, although there will be a short gap. In their words, it may take up to 30 days to come into force after the end of the transition period. The impact of this on business should be minimal. UK businesses will still have access to government procurement in many overseas markets. They may temporarily lose some rights provided by the GPA. EU negotiators are aiming above the GPA. And what are the key differences between the GPA and the EU rules? Well, like the EU procurement rules, the GPA contains a framework of rules for the award of public contracts, including rules on transparency, advertising and competition. However, they are less prescriptive and detailed than the EU rules. A key difference is the range of services and goods covered under the GPA is much narrower than the current EU procurement regime, in particular in relation to utilities and healthcare. And there is also no below-threshold coverage regulated by the GPA. The range of services and goods currently covered by the EU's list of the GPA are set out in the schedules it has lodged at the World Trade Organization. Details of these goods and services can be found on the World Trade Organization's website. The UK intends to lodge an identical set of schedules when it becomes a party to the GPA after the expiry of the transition period. Post 31 December, the areas covered in the schedules should remain open for procurement to businesses based across the UK and the EU. Whether the UK and EU open their respective procurement markets in other areas will be a matter for the current negotiations. And what do we know of the UK's objectives in the negotiations? We know that the Cabinet Office created a Procurement Transformation Advisory Panel in October 2019 in order to advise the government on this issue. One individual who may play a key role in shaping the future procurement in the UK is Dominic Collins, the Chief Advisor to Boris Johnson. It is difficult to assess how influential Dominic Collins remains and whether he will still be in post at exit day, as press reports vary so significantly. What we do know, however, is that he holds very strong views on procurement in the UK. In his blog, Government Procurement, the Horror, he made the following comments. EU law is bad, but UK officials have made it worse. It is complex, slow and wasteful. It hugely favours large established companies with powerful political connections. true corporate looters. It is horrific for SMEs to navigate, and few can afford even to try to participate. But it's not just Dominic Collins who is critical of the current situation. Other senior cabinet members have made critical comments about procurement in recent months, reflecting some of what Dominic Collins has said. A more measured approach to future procurement can be found in the working paper prepared by Susan Arrowsmith, Professor of Public Procurement Law and Policy at the University of Nottingham, which she published on the 10th of January this year. She is a member of the Procurement Transformation Advisory Panel, and no doubt her views will be influential. It is a lengthy report and it goes beyond today's talk to review it in detail. However, she identifies 7 key reform principles which are listed on this slide. These mainly concern the procedure for procuring public contracts in the UK rather than the areas of the market that will be open to EU bidders. Professor Arrowsmith's recommendations are an open contracting approach. This is a continuation of the EU approach of making all procurement information publicly available, and the UK's new Find a Tender e-notification service will be central to this. She advocates a single set of rules for all types of procurement. This would involve the abolition of the distinction between different types of contracting authorities, different sectors, and different types of contract. This is aimed at reducing costs and making rules easier to operate. She proposes legislative simplification. This involves jettisoning unnecessary procurement models, removing incoherent sections in the current law, such as the rules on abnormally low bids, and supplementing simplified legislation with guidance notes for practitioners. But she does advise keeping familiar concepts where there's no reason to change. In other words, don't fix the parts which aren't broken. This would have the benefit of avoiding litigation over the meaning of new concepts where these aren't needed. She also proposes rebalancing the interests. The EU model is very much about opening market to all within the EU. Professor Arrowsmith advocates moving to a system which priorities value for money, sustainability, and reduced procedural costs. She would also like to see a more effective and balanced approach to enforcement. She notes the current system enforcing through the High Court is difficult and expensive to use and does not work for SMEs. Of course, much of this could be achieved under existing EU rules. One key recommendation is to remove procurement challenges from the High Court to a specialist tribunal, much like we have in the Land Tribunal. And finally, she recommends that we have a common framework across all UK jurisdictions. All devolved governments should work together to achieve a single set of rules, rather than differing rules across the different parts of the UK. Professor Arrowsmith's detailed paper provides a careful analysis of how the current system can be improved within the confines of what is allowed under the Government Procurement Agreement. In many respects, it seeks to address the horrors identified in Dominic Collins' blog. Whether it goes far enough for the Conservative government, and whether a deal can be agreed with the EU negotiators above what is currently included in the Government Procurement Agreement, will hopefully be known by the time of our next annual update.
So we're now going to move on to look at some of the recent developments in public procurement law over the last year. And the first couple of cases that we're going to talk about look at the definition of a public contract. So what kinds of contracts fall within the procurement regime. The Court of Appeal looked recently at whether 2 leases of advertising space on the Hammersmith flyover constituted concession contracts for the purpose of the concession contracts regulations. This is the case of Ocean Outdoors and Hammersmith and Fulham Borough Council. The leases had been entered into by the council following a tender process, but not a regulated one. Ocean Outdoors was the incumbent and was very unhappy about losing the contract and having been outbid by quite some way, so it launched its challenge. Back in 2018, the High Court found that the leases did not fall within the concessions contracts regulations, and this decision was confirmed by the Court of Appeal last year. The first point for the court to decide was whether the leases in this case were concession contracts. And the key points here were that the council did not have any statutory obligation to provide advertising services, and the leases did not provide any benefit for the council or its residents. They were purely a revenue stream. The court said that in order to satisfy the definition of a concession contract and come within the regulations, it would have been necessary for the service being provided by the leases to be one which the council would otherwise be obliged to perform itself, so to have some public nature about it. The second point that the court looked at was whether the leases were contracts for pecuniary interests, which is a requirement under Regulation 3. A contract for pecuniary interest is one in which the public body passes responsibility for the provision of a service over to a bidder, either in return for a payment or for the right to exploit the services. A key feature of a concession contract is that the bidder has to take on the risk. They are not guaranteed to recoup their investment or their costs incurred in providing the services. And looking at the leases in this case, the court said that they were not contracts which entrusted the provision of advertising services to the winning bidder. They were genuine leases rather than being contracts for the provision of advertising. And in fact, there was no obligation in the lease at all on the winning bidder to provide any advertising service. Next, the court said that even if the leases had included obligations to advertise, they were nonetheless genuine leases, and therefore they would fall within the exemption which is contained in the concessions contract regulations and also within the public contracts regulations for contracts concerning land. They are not covered by the regulations. And finally, the court said that even if Ocean had been able to get over all of those hurdles, they would not have been entitled to damages because they had been so comprehensively outbid by the winning bidder that they still would have lost the tender, even if a public, proper regulated procurement had been carried out. So not a very successful day in court for Ocean Outdoors. The second case concerning public contracts is just a small but useful confirmation from the European Court of Justice, which might be useful for any NHS or health-related authorities. And that said that the contracts for the provision of emergency ambulance transport do not fall within the procurement regime. They are covered by an exception, which is for danger prevention services. However, contracts for patient transport ambulance services are public contracts, so you do have to continue to procure those in accordance with the public contracts regulations. So moving on to look at when a bidder can bring a challenge, there are three key categories of challenge. The first is where a public body has not complied with a provision of the regulations, and the key obligations there, which are set out in Regulation 18, are to treat bidders equally without discrimination and to act in a transparent and proportionate manner. The second category is where the facts upon which a public body makes a decision are wrong, and the third category is where the public body has exceeded its discretion or made a manifest error. So looking first of all at challenges to tender design, these tend to be based on things like publishing errors, typos, confusing or ambiguous language, requirements that can't be met, insufficient information, or requirements which favour one bidder over another. There's always an issue with timing when it comes to bringing challenges to the design of a tender, because the limitation period for bringing any challenge is 30 days. That can be extended to a maximum of 3 months, but only in very limited circumstances. And due to the length of time that most procurements take, it will often be the case that the 30-day time period will expire perhaps before the deadline for submission of bids, but almost certainly before the outcome of the tender is known. So generally bidders cannot wait and see if they're going to win before they decide whether to bring a challenge which is based on tender design. And we had a very useful reminder of this last year in the case of Royal Cornwall NHS Trust and Cornwall Council. In this case, the NHS Trust was the incumbent provider of sexual health services to the council. And the council re-tendered the service, and the NHS Trust decided not to bid. Subsequently, after the contract had been awarded, it then brought a challenge, arguing that the tender was unlawful, in part because they said that some of the requirements set out in the tender were impossible to meet. The court found in that case that the proceedings were well out of time. They had not been issued until more than 3 months after the tender documents had been published, which is when time began to run for any claim based on the design of the tender. And there was no good reason for the court to extend the time limit. They did not accept the Trust's argument that it had been investigating and that this was a good reason to extend. Although even if it had been, the court can only extend up to a maximum of 3 months in any event, and the claim was just slightly beyond this. So that aspect of the claim was therefore struck out. The court also clarified in that case that public bodies are not obliged to provide information to those who decide not to participate in a tender, such as the Trust in this case. They said this would be extreme, and the duty of transparency only applies to bidders who are actually participating in the tender. While we're on timescales, there were a couple of other cases which considered this last year as well. The first of these is Brace Yourself and NHS England. In that case, the claimants were orthodontists who had challenged the outcome of a tender, and they had issued proceedings seeking an order to set aside the award of the contract to the winning bidder, but they didn't seek damages. The NHS then successfully applied to lift the automatic suspension, which would have left the claimants effectively without any remedy. However, the court then gave them permission to amend their claim to plead a damages claim. Although they were by this time outside the 30-day limitation period, the court said that it could not determine that damages were an adequate remedy for the purpose of lifting the suspension if damages had not been pleaded. And although the limitation period had expired, the court said that this was not really a new claim, but merely a new remedy, and therefore permission was given to amend. However, bidders should exercise a bit of caution before relying on this case. There is no full copy of the judgment available, so we don't have the detailed reasoning from the judge. And it's always preferable to plead all remedies that you might want at the outset of a claim to avoid any future arguments about being out of time. The second case on time limits is the high-profile rail track litigation, the Secretary of State for Transport and Arriva and others. This is a challenge that has been brought by several rail operators to very high-value rail franchise procurement. Rail franchise procurements are expressly excluded from the public contracts regulations, so the court needed to decide what the relevant time limit was for the rail track operators to bring their claims. The claims that they had brought included judicial review, which is subject to a short 3-month time limit, but they had also brought private law claims for damages, injunctions and declarations. And the Transport Department argued that although these were private law claims, they were arising out of public law claims, and therefore the shorter time limits for procurement and judicial review claims should apply. However, the court found in favour of the claimants and decided that the limitation period was 6 years. This case is worth noting, but it has fairly limited application, as the vast majority of the claims that you will be bringing or facing will be under the public contracts regulations or one of the other associated pieces of legislation, in respect of which the much shorter time limits apply. The second key category of challenge is evaluation challenges, and these are the most common type of challenge that we see in practice. Typically, they will involve an argument that the public body has breached one of the procurement principles, so transparency, equality and proportionality. Examples of that might include not correctly applying the marking criteria or being unable to explain the reasons for the scores awarded. Those would both be breaches of the transparency principle. Or where the public body has awarded the same marks to 2 bidders when one answer is in fact better, or the opposite way around. That would be a breach of the equality principle. Alternatively, an evaluation challenge might involve an argument that the public body has made a manifest error of assessment. Although this is a high hurdle and quite a difficult challenge to succeed on, as evaluators have quite a wide margin of appreciation and are entitled to use their judgment. Although evaluation challenges do account for the majority of challenges that we deal with, we have not seen any major cases this year on evaluation. So we can move on to another topic which crops up very regularly, which is disclosure. Disclosure is always a tricky issue because at the beginning of a claim, the public body is the party which holds all the cards, having the key information and documents in its possession. And the test for pre-action disclosure is set out in the 2013 case, Roche Diagnostics. That said, the public bodies ought to disclose the essential information and documentation relating to the evaluation process actually carried out, so that an informed view can be taken of its fairness and legality. We then also have the Technology and Construction Court Guidance Note, which encourages parties to act reasonably and proportionately in providing one another with information. Last year we saw the Ministry of Defence published quite significantly in legal costs for failings concerning disclosure in the case of Serco and the Secretary of State for Defence. This concerned a specific disclosure application that was made post-issue rather than pre-action disclosure, but Serco had made a request for disclosure of the contemporaneous records held by the MOD, which recorded the evaluator's reasoning for awarding their marks to Serco and the successful bidder. The request was made in June 2018, but it was not until shortly before a hearing of the application in February 2019 that the MOD finally agreed to provide the disclosure. The court said there were no sensible grounds for the MOD not to have disclosed the requested documents, and they should have been voluntarily provided months ago. So the court then ordered the MOD to pay Serco's cost of the application on the indemnity basis. That means 100% of their costs or close to it. This is quite rare and should act as a real warning to public bodies that they should provide disclosure of the relevant documents at an early stage when requested, or else risk serious cost consequences if they do not.
Next, we look at a series of cases which dealt with the lifting of the automatic suspension. You will all be familiar with the procedure that applies when the public body have completed their evaluation of the bids and have chosen the winning bidder or bidders. Regulation 86 obliges public bodies to send bidders a notice telling them the outcome, the reasons for the decision, and crucially that a 10-day standstill period will now apply. Regulation 87 provides the public body must not enter the contract with the winning bidder until the standstill period has expired. If an unsuccessful bidder issues legal proceedings against the public body during the standstill period, that automatically suspends the contract award. If that happens, the public body either needs to await the conclusion of the legal proceedings before entering the contract. Alternatively, they have the right to apply to court for an order lifting the automatic suspension so that they can enter the contract. Historically, it has been quite rare for public bodies not to be successful if they apply to lift the automatic stay. In last year's annual update, there were 5 cases where an application had been made, and in 2, the bidder was successful in keeping the suspension in place. This year, bidders have been less successful in the reported cases. There are again 5 attempts to prevent contracting authorities from entering contracts with successful bidders. All of them failed. First, to recap on the test the court applies. This is the long-established American sign-on-bid test. First, the court looks at whether there is a serious issue to be tried. This requires the bidder to prove that they have an arguable case. It is not a high hurdle, and they do not have to prove they'll win at trial. In most cases, this is easily proven. Next, the court will assess whether the claimant can be adequately compensated in damages. If the court decides that the bidder's legal rights can be compensated by a monetary award, rather than being awarded the contract, the court is likely to lift the suspension. As part of this test, the court will consider whether it is fair to limit the bidder to the remedy of damages. The court will also look at the position from the public body's perspective. Can it be adequately compensated by a monetary award if the suspension is kept in place when it shouldn't be? Where this does not provide a decisive answer, the court will look at where the balance of convenience lies. Which outcome carries the least risk of injustice? The court will also consider the public interest at this stage. And if the balance of convenience is even between the 2 parties, the presumption is that the status quo should be continued. So let's quickly look at the recent cases in which the court has been asked by a public body to lift the automatic suspension. In all of them, the unsuccessful bidder showed that there was an arguable claim. The court therefore looked at adequacy of damages and balance of convenience. Starting with Circle Hospital versus NHS Rushcliffe Clinical Commission Group. This was a challenge by the incumbent provider of medical services at the Nottingham Treatment Centre. When the services were retendered, they lost out to Nottingham University Hospital NHS Trust. After a stop-start beginning to the court proceedings, which involved the contracting authority re-evaluating parts of the bid after the Circle Hospital had issued proceedings, the court heard the application to lift the suspension after a second standstill letter had been issued, again naming Nottingham University as a successful bidder. The court ruled that damages were an adequate remedy for Circle Hospital. Specifically, they rejected the Circle Hospital's argument that their parent and other group companies would suffer unquantifiable reputational damage by the loss of the contract, stating that it was the reputation of the claimant company which was relevant, not the reputation of other group companies. They also rejected the argument that damages were not adequate because they would have made some key personnel redundant, noting that the redundancy costs could be included as part of the damages claim. The court also considered the balance of convenience and found this favoured neither party. In those cases, the presumption is to maintain the status quo, or more accurately, the position as it was before the legal proceedings were issued, and to allow the contract to be entered. The court also considered an argument that it was not in the public interest for the taxpayer potentially to pay twice for this contract, once under the contract with the winning bidder, and again in damages for the loss of profits to the unsuccessful bidder. The court was not persuaded by this argument. The judge said, "Since duplication is potentially built into the legislative scheme, I consider that it must have been considered to be a price worth paying in order to achieve proper compliance with procurement legislation." Next, we have Alstom versus Network Rail Infrastructure. This involved the procurement of a £1.8 billion contract for a European train control system for the East Coast Main Line under the utilities regulations. The court again determined that damages was an adequate remedy for Alstom. They rejected arguments that it would be disadvantaged in future tenders because it had not gained experience under this contract. They also rejected the claim that loss of staff meant they could not be adequately compensated in damages. The estimated time of a year to complete the trial and the judgment and deal with any appeal led the court to conclude that the balance of convenience was in favour of awarding the contract now. One point that was argued in both the Alstom and Circle Hospital cases was that damages could not be an adequate remedy as a result of the decision of the Supreme Court in Energy Solutions versus Nuclear Decommissioning Authority back in 2017. That decision was that damages were only available where the breach of the regulations was sufficiently serious. We covered this case in detail in a previous annual update. It followed the decision of the European Court of Justice in Frankovich, which itself is controversial, particularly as there is a conflicting decision of the EFTA Court on the same point. However, what we see from these two cases is that a practice seems to have developed for contracting authorities to get around this potential defence by conceding that the breach, if proven, would be sufficiently serious to justify a damages award. However, there is a comment from the judge in the Alstom case that a breach that was not sufficiently serious to justify damages was unlikely to be sufficiently serious to justify setting aside the contract. That meant that if Alstom could persuade the court that the breach was not sufficiently serious, such that damages were inadequate, the case was still likely to fail at the balance of convenience stage. Now, it remains to be seen whether this comment will see an end to the type of practice we've seen where contracting authorities are conceding the Frankovich argument. Next, we have the unreported decision of Brace Yourself versus NHS England, which Emma mentioned earlier, involving the procurement of orthodontic services. The dentists argued that the automatic suspension should be maintained because damages would be an inadequate remedy because their business would fail if they were not awarded the contract. The court readily rejected this argument, noting that only limited weight could be given to this assertion as the evidence had only been given by their solicitor on instruction. And the court also noted that the claimant's principals were highly qualified dentists who would do all they could to mitigate the loss of the contract. Next, we have Iridium Concessiones against Transport for London, which involved the procurement of a £1 billion contract for the construction of the Silvertown Tunnel, which is a road tunnel under the Thames in East London. Iridium issued legal proceedings against TfL, challenging the tender process and the tender award, and brought into play the automatic suspension. Shortly afterwards, the TfL wrote to Iridium's lawyers asking them to consent to the lifting of the automatic suspension without the need for a court hearing. There followed a standoff, with Iridium's lawyers saying they needed more information about the reasons for lifting the stay before they could decide whether to consent, and TfL's lawyers taking the position that Iridium had enough information already. Neither party backed down, and TfL made a court application, ultimately providing detailed reasons for needing to lift the suspension, although some of it was initially only disclosed into a restricted confidentiality ring. Unlike the previous cases mentioned, Iridium consented to the suspension being lifted before the court hearing, although not before significant legal costs had been incurred by both sides. All that remained was for the court to decide who should bear the wasted legal costs of preparing for the court hearing. The usual rule is that the losing party, in this case Iridium, should pay the costs of the winning party. The court, however, was critical of Transport for London's approach in refusing to provide Iridium with the detailed reasons for lifting the suspension before they made the application to court. They referred to the TCC Guide on Procurement Challenges, which, as mentioned earlier, obliges parties to act cooperatively and reasonably in dealing with all aspects of litigation. The parties should also act reasonably and proportionately in providing one another with information. Similar to the Serco case on disclosure, the court showed its displeasure with Transport for London by penalising them on the costs award. They discounted the costs that Iridium were ordered to pay by 40%, which in monetary terms was a reduction in £70,000. And finally, we have the rather unusual procurement challenge in Kenton Contractors versus Haringey London Borough Council. This involved a tender for a below-threshold construction contract valued at £630,000 to execute a road improvement works to Chestnut Road between Tottenham Hale train station and the new stadium for Tottenham Hotspurs. Since the contract was below the construction works threshold, which was 4.5 million at the time, the legal remedies under the Public Contract Regulation 2015, including the automatic suspension, were not available. This meant that the unsuccessful tenderer's only option was to challenge the decision by judicial review and to apply for an interim injunction to prevent the council from awarding the contract to the successful bidder. This was a claim beset with problems, not least because the claimant delayed bringing the claim, for which they were heavily criticised by the court. The test for obtaining an injunction is the same test as for resisting the lifting of an automatic stay. I mentioned earlier that the first limb of the test, showing that you have an arguable legal case, is usually proven as a matter of course. In this case, they did as well, but only just. The court held that there were strong grounds that the procurement was not even subject to legal challenge. They had argued that the EU procurement principles applied, because the contract was open to bidders from other member states to participate in, but the court did not accept this. The court had little difficulty finding that the balance of ingredients lay in rejecting the application and allowing the contract to proceed. So what lessons can we learn from these 5 cases? It is still the case that defending an application to lift the automatic suspension is very difficult. The unsuccessful bidders failed in all the cases discussed today. Good news for contracting authorities, but bad news for dissatisfied bidders. It is hard to find any pointers from this year's cases to help bidders identify grounds on which the automatic suspension will be maintained. These cases show that the court will be slow to accept claims that reputational damage or loss of business or loss of key staff is a type of loss that cannot be compensated for in a monetary award. There are cases historically where these arguments have succeeded, but they are very much the exception. And finally, a word of warning for contracting authorities: pay careful attention to your obligations under the Technology and Construction Court Guide to cooperate and provide information to bidders before applying to lift the automatic suspension, or you may find yourself penalised in costs.
And finally, we're going to look at the remedies available where a challenge is successful. The remedies depend on whether the contract has been awarded yet or not. If the automatic suspension was upheld and the contract has not been awarded, then the court can set aside a decision made by the public body, so usually the decision to award the contract to someone else. What the court cannot do is order that the public body must award the contract to the challenging bidder. That was confirmed in the MLS case a couple of years ago. If the contract has already been awarded because the court lifted the automatic suspension, then the bidder's remedy is confined to damages, and damages are also available in cases where the contract hasn't been awarded. But as Chris mentioned, damages will only be available if the breach of duty by the public body is deemed to be sufficiently serious. We are still waiting for the courts to really clarify what sufficiently serious actually means. We've had a small amount of guidance this year, such as in the Ocean Outdoors case, which I mentioned at the beginning, in which the court said that a failure to comply with the regulations where you should have done would not necessarily be a sufficiently serious breach, because the court said if that were the case, then all procedural breaches would give rise to a significant damages claim. The court said that it has to take into account the facts of each case, and the existence of a procedural error will not always give rise to a damages claim. However, we do still await much more guidance from the courts on this important issue. If the contract has already been awarded, then damages are usually the only remedy, but there are limited circumstances in which the court can make a declaration of ineffectiveness. This is only available for serious procedural breaches of the regulations, such as a failure to advertise or a failure to hold a standstill period. It's quite rare, and there's only been 2 UK cases to date in which a declaration has been made, one Scottish and one English. But we did see an unsuccessful attempt to obtain a declaration of ineffectiveness this year in AEW Europe and Basingstoke and Deane Borough Council. In this case, Basingstoke had entered into a development agreement in 2018 following a negotiated procedure that they carried out in 2013 to 14. They had published an OG notice in 2013 which sought bids for the redevelopment and regeneration of the Basingstoke Leisure Park, which included a cinema, swimming pool, ice rink, bowling alley and restaurants, etc. But the contract which was ultimately entered into in 2018 was for a large scheme. It was double the size of what had originally been envisaged and included a much greater retail presence with a new designer outlet centre. And AEW challenged the contract on the basis that the agreement that was entered into was materially different in scope from the works and services that had been identified in the OG notice. There is, of course, a detailed body of case law on variation of public contracts and the concept of material or substantial change. However, the court said it would not be fair to apply this in the context of declarations of ineffectiveness. They said that because ineffectiveness is such a draconian remedy, which brings to an end an otherwise lawful relationship, that a broad brush approach needs to be taken. The council in this case had published a valid OG notice, and there was a sufficient and close connection between that notice and the development agreement that was subsequently entered into. If the council had, for example, published a notice for a regenerated leisure park, but then let a contract for 1,000 homes to be built instead, that would be different, the court said. But here there was a sufficient connection, and therefore no declaration of ineffectiveness was available. This will be a welcome decision for public bodies because it's very common when using the negotiated procedure for the scope of a contract to undergo some significant variation before the agreement is finally concluded. It would be wise though, particularly when, like here, there have been some years passed between the publication of the notice and the conclusion of the contract, to check back to your original notice before you conclude the contract and just be satisfied that you haven't gone too far away from what was originally envisaged and published in your notice. And finally, we're going to look at the important decision in Amy Highways and West Sussex, which concerned the abandonment of a procurement. This case potentially has quite big implications for public bodies because it's long been thought that abandoning a procurement will defeat any claim brought by an unhappy bidder. The case concerned a tender for highway services, and Amy came second by 0.03 points, and the issue proceedings, which the council then applied to strike out. When the strikeout application failed, the council decided to abandon the tender instead. They hoped that in doing so, this would effectively bring Amy's claim to an end, and that was the key driver in their decision to abandon. They would not have made that decision had it not been for the challenge. However, Amy was not content with the chance of bidding again in a re-procurement, and they issued a second claim, alleging that the decision to abandon was unlawful and did not defeat their first claim. The court therefore had to determine, as a preliminary issue, whether the abandonment was lawful and whether it had the effect of bringing that first claim to an end. It decided that public bodies do have a wide discretion to lawfully abandon a tender. Lawful reasons for doing so might include where pursuing the procurement would not lead to the award of the most economically advantageous contract, or where abandoning would prevent a future breach of duty that would then give rise to a future claim. So the court decided that the decision to abandon was not in itself unlawful. However, it did not have the effect of defeating Amy's first claim, which was what the council had hoped. The court said the claim was based on breaches of duty which allegedly took place during the evaluation process, so before the decision to abandon had been taken. And if Amy had been able to prove those breaches of duty, they would have won the contract and they had therefore suffered loss and damage. The council would not have abandoned the tender if Amy had not brought a challenge. So the court decided that abandoning a tender can prevent a future claim from arising, but it cannot extinguish a claim which already exists. Bidders have always had to accept the risk that a public body may decide not to award the contract, but the court said they do not have to accept the risk that they will be deprived of an already accrued cause of action. This is an important decision for public bodies. Abandonment is often suggested at an early stage as a way of diffusing a claim. Some bidders will be content with that and the opportunity to have another go, but others will not be, and public bodies will need to look very carefully at the decision to abandon and consider whether a cause of action has already accrued. In many cases, it already will have, and just need to be aware that abandoning will not necessarily extinguish a potential claim.
That brings an end to today's presentation. Thank you to everyone for listening to the webinar, which we hope you found useful. If you are a public body or a bidder who has any questions about any of the issues raised in today's webinar, please feel free to contact us on the details below. And if you're interested in receiving further information about subjects covered, and in particular the Brexit negotiations, information will be published on our website. Thank you and goodbye.